Alex here with part 73 of the My Docket series on child custody and visitation. As with my previous video, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I am not in the middle of this right now. My case is completely and totally over. It's closed, it cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series has to do with giving my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. So, we left off with, for the most part, very good news in the previous video. That was the hearing video on my efforts to get my son put into Coral Academy of Science. This video goes into a little bit more of the negative aspect of the case, and that is that I lose my appeal to the Supreme Court of Nevada. This is the second appeal that I have filed, and this is the appeal that I've already talked about this at length, but for anyone who needs a refresher, what I was trying to do was correct, which is to get my ex's fictitious address canceled, and I do eventually win this, but the way that I approached the problem was not, what's the word that they use? Their exact words, if I remember correctly, are that I used the wrong legal vehicle. What they mean by vehicle is, I guess, the way to sort of get something into the court. And after I lose this appeal, I will file I'll file all of the same stuff that I filed previously, only I'll use a different legal vehicle, and this is the occasion where I actually win the case. We're going to go into that a whole lot more into the next video, because you are going to quite literally see that I lose this appeal in part 73 and that I file the petition for writ of mandamus in part 74. So as soon as I got the order of affirmance, I followed up immediately with a petition for writ of mandamus, which is the correct legal vehicle, and I will be, of course, winning that case. So my mindset, I think, very positive between the victory in part 72 and what's going to happen now in part 73. And I guess I really can't say that it affected me too much. I'm sure that I was very, very annoyed with the legal system. I felt like a tremendous amount of time was being wasted. I felt like they didn't really care. Looking back on this in hindsight, I think that they didn't have to do what they did. They didn't have to entertain my petition for writ of mandamus at all with the manner in which I filed it. And so I suppose it's kind of one of the problems with idealizing the legal system, the court system, the Supreme Court, when you're just an average person. And in hindsight, I can tell that they were just doing what they've done with all the other tens of thousands of cases that they processed. They didn't single me out or anything like that. And in a way, when we get to the end of the petition for writ of mandamus, you could say that they kind of did single me out in a positive way. And I'm going to talk about that a whole lot more when I actually get into that sort of filing. That whole docket is about to open up next part, which is part 74. So there's no reason for me to talk about that too much right now, when we're going to end up getting into that anyway. All of that being said, let's go ahead and take a look at what the Supreme Court has filed. Here we have the Supreme Court of Nevada's Order of Affirmance. As I've mentioned in the previous appeal, an Order of Affirmance is an order that takes the decision of the lower court and upholds it. Most people are used to that sort of terminology in the media. When a decision is upheld on appeal, most people know that nothing was changed, there was nothing disturbed about that decision that was entered by the lower court. So that's what they're doing here. In the first paragraph, they deny the petition they mention that what I am appealing is the lower court's denial of a petition for judicial review. And they identify the judge who has entered that order as Mr. Stephen Kasach, District Judge Stephen Kasach. In October of 2009, we're going into the next paragraph, they summarize that I filed a petition in district court challenging the Secretary of State's decision to issue a fictitious address to my ex. Secretary opposed the petition, and let's see here, the decision was, okay, hold on a second. The Secretary proposed on 2 grounds that the judicial review was improper since the decision to issue the address was not a contested case. I talked about this a lot already, but the statute or the statutory scheme that discusses when petitions for judicial review are to be entertained requires that the decision that was made by whatever government entity or agency was a decision made after a contested case. And that's not what happens in the fictitious address process. I've talked about this before, but it's just an application. My ex filed an application much like anyone would file a job application or a bank loan application, anything like that, and they reviewed her application and decided to give her the fictitious address. I'm not involved in the process at all. There was no contest at anything, and for those reasons, technical as they are, you cannot get judicial review. And I'm going to go ahead and deal with that in the next video, but let's move on for now. Judicial review of administrative decisions is limited to parties of record to an administrative proceeding who are aggrieved by a final decision. So they're putting it all together for me. They're saying that the decision must have been made administratively, which is what the Secretary of State did. They're saying that we have to be parties of record, which we weren't. And what they mean by that, or at least what I assume they mean by that, is that the proceedings in the administrative tribunal are proceedings where papers are filed, where like if there's a hearing, like it's recorded. For example, an unemployment hearing, that would be a decision that you could get petition for judicial review filed on. There is 2 sides. They file papers, or they just they might just talk to somebody over the phone, but that gets recorded. And then if there's an appeal, there's a record, there's like a hearing, they record all of it, they transcribe it if you need it. That's a decision that follows an administrative proceeding where the parties were of record. And I mean, right there, I just kind of led into the last piece of that puzzle, which is that a final decision has to have been made. And I guess you could sort of say that a final decision was made, but it doesn't matter really, because I don't satisfy any of the other necessary parts of that. There was no sort of adversarial process that I was a part of. There was nothing, there was no like hearing where they recorded us. There was no filings except for my ex's application. It wasn't contested at all. She just went on her own and asked for the fictitious address. So, I mean, you have to satisfy all of these requirements, and you can see where they cite a case, Private Investigators Licensing Board versus Atherley. That's a case in 1982 where they contemplated this problem and they settled in the law what was to happen in this particular sort of dispute, which is a dispute that came up in my case, where the Secretary of State is saying, hey, there was no administrative proceeding where, you know, this guy, Alex, was a party to. We didn't hold any sort of contested case between the 2 of them. All we did was take one person's request and gave them what they asked for. So the Supreme Court of Nevada is agreeing with the Secretary of State that there was no contested case, and therefore I cannot get relief under what they call the Nevada Administrative Procedure Act. So let's go into the next paragraph. On appeal, I am conceding that my petition was improper, acknowledging the soundness of the Secretary's argument, and that the dispute was not a contested case, as I've conceded. And it doesn't matter. Even if I didn't concede this, I'd be wrong. This is not a contested case. They're right. So I was admitting to the Supreme Court that, yes, this is not a contested case. I'm conceding that the district court lacked jurisdiction over my petition, and because this court will affirm the decision of the district court that reached the right results, albeit for the wrong reasons, they order the judgment affirmed. So this last little sentence here is actually very helpful to me, because it opens the door for me to continue to prosecute this type of case, because they're not saying that I was wrong because of all of the reasons that the judge said I was wrong. In fact, the judge was wrong in his decision, but they're saying that they're going to go ahead and uphold his result, which was to deny the petition, because this other reason that the judge may have not mentioned or relied upon is actually the correct reason as to why the case should be thrown out. So this allows me to say, hold on a second, I can reject the district judge's decision, and I can basically accept that, as the Supreme Court has stated, they lack jurisdiction to consider the petition. And so what I need to do is find out what it is that I need to file so that they do have jurisdiction. I need to find out what the proper filing is to get the attention of whatever particular court that I need to get the attention of. And that's what we're going to go into the next video, where I actually file the correct pleading. And that's the end of this order. Moving on to the remittitur. I've talked about this once before, and I believe I do have a video titled Remittitur. The remittitur is a way for the Supreme Court to say that everything in this case on appeal has been wrapped up. We're done with it, and we're sending it back to you. This is the receipt for the remittitur by the district court clerk, and this indicates that the jurisdiction of my case that had been divested originally when I filed the appeal is now back and vested with the lower court, the district court. If you want to know more about what I'm talking about, please watch my video, Jurisdiction Divested on Appeal. Here is the clerk's certificate, and in this clerk's certificate, it's indicating to the lower court that the decision that I filed an appeal on was affirmed. It basically lets the lower court know there's nothing that you have to do, everything that you entered was correct, and it all remains in effect. Here we have the notice of change of address that I filed in the Supreme Court, and I have mentioned in a video and in numerous other videos in my docket series that this is a filing that is crucial. When you move, you must file this particular paper, and the reason why is because if you don't, and people send filings to your old address, that counts as you having been served even though you don't live there anymore. If you want to know why this is the case, please watch my video, Notice of Change of Address. I'm not going to talk about it again because I dedicated a video specifically to that topic. Certificate of NRCP 5 service. This rule doesn't apply in the Supreme Court, but there is a similar rule that for the most part is the same thing. It's NRAP, I don't know, like 28 or 38, something like that. Anyway, this is a certificate that indicates to the Supreme Court that I personally handed a copy of this notice to my ex and to, I'll highly doubt that happened. This is probably a typo. This is the Solicitor General in Carson City. So most likely this is a typo. I highly doubt I personally served him. I probably meant to make this say that I served him by mail, and I probably just pasted this in here. But who knows? I mean, I'm not 100% sure. Maybe I did arrange for somebody to serve that person and it wasn't me, which in any case, then the signature is wrong. Most likely, this was a document that was served by mail upon C. Wayne Howell, not personally. Okay, we have, the next three filings are not filings that were in the Supreme Court. Or maybe this one was, but the next one wasn't. I'm going to take a closer look when I get to the next. This doesn't seem right at all. Yeah, I can tell this is, okay, the clerk of the court, Joey Hastings, that's not a Supreme Court clerk. So this is so weird. So even though this is captioned in the Supreme Court of the state of Nevada with a case number from the Supreme Court, this is a document that was actually filed in the district court. It's really weird the way that they did this, but it doesn't matter. What I was going to say a moment ago is usually I won't go through documents that are filed in a different docket, but in this case, I decided to go ahead and do that with this video because this case, CV 09-03089, there's nothing else that happens in this case substantially, so there's not going to be another video on a filing in CV 09-03089, and for that reason, since I'm not going to do a video on it, I went ahead and lumped these three district court filings into this Supreme Court video. So just letting everybody know, these next three filings are filings that are in the lower court and the district court, and if you think about it, the only other thing I could have done was dedicated an entire video to these three ancillary filings, which would be a waste of everyone's time because they don't have anything substantial about them. They're just those technical sort of housekeeping type of papers that are filed, and you'll see for yourself when I go into the next two. So the next one is another notice of change of address. This was filed in the lower court, CV 09-03089, and it's the same as the one that I went through previously. It just lets the lower court know that I've moved. And the last filing is the clerk's certificate. So you could imagine these previous three filings in their own video would kind of be silly. Nothing really happens. It's just additional paperwork that gets sent in when certain things happen, in this case when an appeal is resolved, and this is just the district court's filing of the same clerk's certificate, acknowledging that the Supreme Court affirmed the decision. Going into the aftermath, I filed two of those documents, notice of change of address in both courts, the district and Supreme Court. Those are free filings, so I incurred $0 in costs. The government didn't file anything, so they incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. The government would have maybe spent at most 15 minutes on these 6 documents, and that's because nothing really happened that they would have to do any work on, any subsequent work on. This decision of the lower court was upheld. Everything's going to remain the way it was before. The only thing that they might have to do is update their computer system with regards to where I live now, in case anything else gets filed or has to be filed. And so I think 15 minutes for all 6 of those documents. We've got both orders, both notices, the remittitur, and the clerk certificate. I think 15 minutes is reasonable. And at the rate of $250 an hour, we're looking at $62.50 in attorney fees. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.